Good morning, everybody. I want to start by welcoming you to this shadow hearing, Kidnapped and Disappeared, Trump's Weaponization of the Immigration Courts. This is our second shadow hearing in a series of hearings that I plan to hold over the coming months on how the Trump administration is destroying our immigration system and trampling our constitutional rights by kidnapping and disappearing people. This not only impacts immigrants, but U.S. citizens, our economy, and who we are as a nation. A few housekeeping items before we begin. While today's shadow hearing is not a formal hearing, I do plan to operate it as if it were, with opening statements from our witnesses and then 5 minutes of questions from our members. I would ask members to keep their cameras off until it is their turn to speak. And when you have 1 minute left in your questions or opening statement, a timer will appear on the screen to let you know and count down your final minute. I now recognize myself for an opening statement. I would like to welcome our witnesses, members of the Judiciary Committee, as well as members from our wider Democratic caucus to today's shadow hearing on the Trump administration's weaponization of immigration courts. Republicans like to talk about how they support immigrants who, quote, do things the right way. Now that they control Congress and the White House, they should be putting their money where their mouth is and ensuring that the legal immigration process remains open to those who pursue it. But that is not what is happening. The Trump administration is using a variety of means to go after every immigrant they can, regardless of legal status or criminal record. They've arrested people with valid green cards, students, specialty occupation workers, and those who have valid lawful status, like parole or temporary protected status. They have arrested people at their citizenship interviews, their check-in appointments with Immigration and Customs Enforcement, and increasingly at the immigration courts. The actions are a direct attack on the legal immigration system and the people who are trying to follow all the legal steps. Outrageously, ICE is now doing an end run to deny people due process and a fair day in court. The people who show up to their ICE check-ins and their immigration court appearances are the ones doing everything possible to do things, quote, the right way. But upon their arrival, they find that instead of their standard check-in, there is an officer with handcuffs. Instead of being given the opportunity to prove in court their eligibility for asylum or some other immigration status, the Trump administration is dismissing their cases and then stationing an ICE officer to arrest them in the hallway and take them to a poorly maintained, privately run, overcrowded immigration center, or even just a holding cell in a basement. Now, you might think that it seems very inefficient to dismiss a case in immigration court only to detain people minutes later. Why are they doing this? The answer is twofold. First, ICE agents are under pressure from Stephen Miller and Tom Homan to meet their daily arrest quotas. So agents are doing everything they can to inflate their arrest numbers, not going after the, quote, worst of the worst as Trump promised, but asylum seekers, families, relatives of U.S. citizens. In fact, recently released data shows that 63% of those detained by ICE have no criminal conviction whatsoever, and 93% have no conviction of any violent assault. Of those who have a conviction, most are traffic or immigration related. They are the people working every day as caregivers looking after the elderly, or construction workers building homes after the fires, or farm workers harvesting the food on our tables. Many are married to U.S. citizens or have U.S. citizen children. They are contributing to and part of our communities. The second reason this is happening is much more sinister, and it is a complete end run around the constitutionally protected right of all people to due process. What the Trump administration is doing is dismissing the court case simply so that now they can arrest people and place them into what is called expedited removal. Expedited removal is a process by which ICE officers can summarily remove certain non-citizens from the United States without a hearing before an immigration judge. Imagine the heartache of an immigrant who has followed all the steps, prepares and waits for months or years for these court hearings, shows up, is momentarily thrilled that the department has, quote, dismissed the case, only to find that this now means that they never even got to present their case and they're going to be deported with no day in court. It's absolutely outrageous and simply another bad faith way to deny people their fair day in court and further destroy the right to due process. Theoretically, undocumented immigrants placed in expedited removal proceedings are entitled to access the asylum system if they express fear of persecution, torture, or returning to their home country. But practically, we have long heard of abuse of this process by ICE agents, as it has little transparency or accountability and no guaranteed access to counsel. Under these circumstances, why would anyone show up to their check-ins or hearings? People who are trying to follow the rules are actually being disincentivized from following the law. And we've seen the result. After ICE's heavy-handed enforcement in New York immigration courts, a recent New York Times article revealed that over half of the immigrants scheduled for court appearances did not show up. But this, too, is a massive catch-22, an impossible choice for people to make. Because when you skip your court date, you are labeled an absconder and you're ordered removed in absentia, meaning that you can be deported again without any meaningful due process. Similarly, if you skip your ICE check-in, you violate the terms of your status and you can be put in immigration detention. So for immigrants who are actually trying to follow the rules within the immigration system, you either take a chance at being arrested, detained, or deported with no due process, or you break the rules and you become a target for ICE. What a complete abuse of trust of the people in a system. It will take years, if not decades, to restore trust in the legal immigration system when just compliance with the immigration system actually gets you thrown in jail with no due process. Democratic lawmakers are standing up to bear witness and to say that this is unacceptable. And what has DHS done in response? Manhandle, assault, and arrest members of Congress, elected officials. In New York, DHS agents arrested a member of Representative Jerry Nadler's staff and New York City Comptroller Brad Lander in separate incidents, both of which were connected to these alarming immigration court arrests. Just when you think that this administration cannot sink any lower, they get out a shovel and keep digging. I am grateful to the witnesses for coming today to shine a light on this latest disgusting tactic from an administration that knows no shame. And I'm also grateful to my colleagues for all of their work and attention on this issue and for being with us for this hearing. I look forward to our discussion. It is now my pleasure to introduce today's witnesses. Jillian Rowland-Kaine is the Interim Director of Programs at Immigrant ARC. At iARC, Ms. Rowland-Kaine launched iARC's Friend of the Court program and has organized several rapid response clinics. Ms. Rowland-Kaine began her career in immigration at the New York Immigration Coalition, supporting many special project initiatives. She completed her JD from City University of New York School of Law, her Master of Science in Human Rights and International Politics from the University of Glasgow in Scotland, and her Bachelor of Arts in International Relations from Connecticut College. The Honorable Ashley Tabaddor served as a senior Biden-Harris appointee as chief counsel at U.S. Citizenship and Immigration Services, Department of Homeland Security, where she played a key role in shaping national immigration policy. Previously, she served as a U.S. immigration judge for over 15 years and was elected president of the National Association of Immigration Judges, where she was a leading voice on judicial independence and immigration law reform. Judge Tabaddor earned her BA cum laude from UCLA and her JD from UC College of the Law, San Francisco. She is no longer serving in that role and participates in professional activities in her personal capacity. Azadeh Erfani is the Director of Policy at the National Immigrant Justice Center. Ms. Erfani has worked for over a decade in immigrant and human rights, defending detained adults, children, and youth from deportation, advocating for survivors of gender-based violence, and leading or supporting impact litigation and policy change to advance racial justice and civil rights. Bettina Rodriguez Schlegel serves as Chief of Staff at the Acacia Center for Justice, and has over a decade of experience working for immigrant rights. Prior to joining Acacia, Ms. Rodriguez Schlegel directed the Legal Orientation Program and Immigration Court Help Desk at the Vera Institute of Justice. After graduating from the UC College of Law, San Francisco, Ms. Rodriguez Schlegel was a staff attorney for the Linking Immigrants to Benefits and Resources and Education, or LIBRE project at the Legal Aid Society of San Mateo County, California. Ms. Rodriguez Schlegel earned her bachelor's degree from Wesleyan University. We welcome all of our distinguished witnesses and thank you for participating in today's hearing. We ask that you summarize your testimony in 5 minutes, and to help you stay within that time, there will be a timer that will appear when you have 1 minute left. Ms. Rowland-Kaine, you may begin.
Congresswoman Jayapal and distinguished members, thank you for inviting me to speak today. My name is Jillian Rowland-Kaine, and I am the Interim Director of Programs at Immigrant ARC, a network of over 80 immigration legal service providers across New York State. I lead our Friend of the Court project, which assists unrepresented individuals at the 290 Broadway and the 201 Varick Immigration Courts twice a week. I also lead the Volunteer Court Observation Project Immigrant ARC launched at the beginning of June that covers all 82 immigration court dockets across New York State. At IARC, we believe in the sanctity of the courtroom and the importance of due process. In the last few weeks, ICE has begun a chilling campaign of arrests at immigration courts in New York and across the country. What we're witnessing isn't just an unprecedented policy shift, it's an erosion of due process. In the last 3 weeks, our Friend of the Court team and our volunteer observers have personally witnessed groups of more than 30 plainclothes ICE officers, many masked, stationed throughout the court buildings, and even hovering at the entrance to our pro bono office, where confidential conversations frequently take place. We've seen government attorneys seek to dismiss case after case from the immigration court docket, not to close them, but to pave the way for ICE to arrest them on their way out and put them in expedited removal, allowing ICE to deport individuals without a fair hearing before a judge. We've also seen judges dismiss cases even when the person has a pending asylum application, even when the person pleads with the judge for a chance to continue fighting their case and sharing how fearful they are of being sent home. And we've seen families cry as their loved ones are pulled away and arrested. I'd like to tell you about a few of the individuals I personally assisted who were subjected to this process. As this policy first rolled out, we were assisting 3 gentlemen. One had just suffered a motorcycle accident and was appearing on crutches, leaving his 6-year-old daughter safely at home. When the government moved to dismiss each of their cases, the gentlemen expressed their confusion. They expressed their fear of returning to their home countries and their objection. Although the judge granted each of them 10 days to respond to the motions, that did not seem to matter. We brought them to our pro bono office and had to have the extremely traumatic conversation of letting them know that they were very likely going to be detained as they exited the building. We had to ask each of them to reach out to their loved ones and tell them that they might be separated for following the rules, appearing for their immigration court hearings. As we escorted them down and exited the elevators to the building lobby, a group of around 30 ICE agents just converged on them, detaining them one by one. In another scenario, I assisted a married couple in their late 50s. Both had filed for asylum and both were in proceedings together. They had no family and no one here but each other. The government moved to dismiss only the husband's case, and they both immediately broke down in tears in front of the judge. And this is how these motions to dismiss are impacting families who are on the docket. This is indiscriminate and it is cruel. There is no pattern to whose cases the government seeks to dismiss. People who entered lawfully on parole or without inspection, people who have lived in the US for more than 2 years, and people who have been here for less. And we have seen ICE arrest people even if the judge didn't agree to dismiss their case, or when they reserved their right to appeal. There is one commonality across the cases that we've seen dismissed in New York courts, however. Almost every single one of them is unrepresented. This appears particularly calculated. The climate of fear is already causing people who would otherwise comply with their obligations to be wary of coming to court, leaving people at risk of receiving in absentia removal orders, blocking their pathway to safety. This environment undermines any notion of the fair administration of justice. Every day, Immigrant ARC's staff, members, and volunteers are in these courtrooms, often the only ones there to stand beside immigrants facing an unjust system. We're working to uphold the basic promise of fairness, that no one should face this system alone. We thank you for holding this hearing and shining a spotlight on this crisis in our immigration courts. Thank you.
Thank you so much, Ms. Rowland-Kaine, for your testimony. Now I'd like to recognize Ms. Tabaddor for 5 minutes.
Thank you so much. Congresswoman Jayapal and members of the committee, thank you for the opportunity to appear before you today. My name is Ashley Tabaddor. I recently concluded almost 30 years of federal service. Wow, even that took myself by surprise when I said it. 30 years of federal service, including more than 15 years as an immigration judge in Los Angeles. And most recently, I served as a chief counsel of United States Citizenship and Immigration Services at DHS during the Biden-Harris administration. So I'm very happy to be here to share my experiences and observation. And I particularly wanted to highlight some of the key points of your introductory statement in the context of the immigration court system. So let's begin with that foundational concept, due process. And what does it mean when you speak of due process in a judicial or a court setting? In a court setting, it means not only that each individual part must be fair, but that the system as a whole must work together fairly. So imagine a courtroom as a machine. For it to function fairly, it needs several key components. First, an independent and impartial judge. Two, a balanced adversarial process. And three, a safe and accessible forum for all participants. The immigration court system, unfortunately, has always had a structural flaw. Most people don't know that it's housed within the Department of Justice, a law enforcement agency. But still, before, there were guardrails. Judges were protected by civil service rules and a union, giving them insulation from political pressure. That changed when, during the first Trump administration, the judges' union was targeted as the only union for decertification. And now the administration asserts that immigration judges are at-will employees who serve at the pleasure of the president. This directly undermines their independent decision-making authority, often placing judges in the impossible position of choosing between upholding the rule of law and safeguarding their jobs. Next, a fair system requires a level playing field between the parties. We've heard from our first witness about the concerted effort to focus on a non-represented or pro se respondent. Immigration law is extraordinarily complex, often called second only to the tax code. DHS is represented by trained counsel, but non-citizens have no right to appointed counsel, even in life or death matters. To mitigate that imbalance, the court had historically relied on programs like the Legal Orientation Program, the Help Desk, and access to counsel for unaccompanied minors and mentally incompetent individuals. But those programs have now been removed, the removal of which has upended any semblance of a level playing field. And third, and an equally essential part, the court must be a safe place. Immigration courts are now being turned into enforcement zones. In cities across the country, from West Coast to East Coast, ICE officers in plain clothes are stalking and arresting people in the courtrooms at the courthouses, even when cases are still pending or have just been dismissed. This message, come to court and you may not leave, stifles participation and erodes trust in the court's integrity. And as we've also heard, separate and apart from the attack on the system, we are seeing an effort to bypass the system entirely. DHS is increasingly dismissing cases that it initiated initially under Section 240 of the law, where individuals appear before a judge, and shifting them to an expedited removal process, where there is no judge, there's no hearing, and virtually no review. This effectively strips people of access to the courts altogether. These actions are not isolated. They are coordinated, systemic, and reflect the deliberate erosion of the legal protections that define due process under our Constitution. As a former judge, I can tell you, when one part of the framework breaks, when judges are undermined, when legal support disappears, when people are too afraid to show up, the entire system fails, not just for immigrants, but for all of us. We must focus on our core values: fairness, transparency, and the rule of law. Courts must be places of justice, not traps. While individual outcomes matter, and we should focus on those, I urge this committee and the public to pay close attention to what is happening to the system as a whole, and to take action before it's too late. Thank you.
Thank you so much, Judge Tabaddor. Next, let me recognize Ms. Rodriguez Schlegel for 5 minutes.
Good morning. Thank you, Ranking Member Jayapal and members of the committee for holding this important hearing and for allowing me to testify among my esteemed colleagues today. My name is Bettina Rodriguez Schlegel, and I am the Chief of Staff at the Acacia Center for Justice, a national immigration legal services nonprofit that partners with human rights defenders across the country who protect the legal rights of immigrants. Prior to President Trump's inauguration, Acacia administered 8 federally funded immigration legal services contracts. Those legal services programs offered crucial due process protections for vulnerable indigent immigrant communities. They served as a necessary stopgap against arbitrary detention and expulsions without due process of law, and their loss is sorely felt by the communities we serve. Of the 8 programs, 7 were funded by the Department of Justice, and I will briefly summarize some of them now. The Legal Orientation Program for Detained Adults, or LOP, was created in 2003 to provide legal assistance to people in immigration detention and enjoyed bipartisan support for decades. Prior to joining Acacia, I served as the LOP Program Director for several years and can speak to the value of this program, which reached the most marginalized people in detention, including people seeking asylum from all over the world, and offered them basic information about our complex immigration legal system in their best language so that they could make informed decisions about their cases with dignity. The LOP for custodians of unaccompanied children was created to fulfill the government's obligation under the Trafficking Victims Protection and Reauthorization Act by ensuring that the sponsors of unaccompanied kids receive basic information about legal obligations and how to protect children from mistreatment, exploitation, and trafficking. Another program, the Immigration Court Help Desk, was structured like the LOP and served people without lawyers who were not in detention at 23 immigration courts around the country. These are many of the same courts where ICE has been conducting arrests in recent weeks. The National Qualified Representative Program was created in response to a 2013 court order holding that the Rehabilitation Act of 1973 requires the appointment of counsel as a reasonable accommodation for people in detention who are deemed incompetent to represent themselves due to serious mental health conditions. And finally, the Legal Services for Reunified Families program was created as part of the settlement in the Miss L v. ICE lawsuit to help address family separations under the first Trump administration. Of the 7 DOJ-funded programs, only a small part of our work under NQRP remains active, the portion required by the Franco injunction, which covers just 3 states for a program that used to assist people across the country. Acacia is also still providing services under a contract with the Department of Health and Human Services, our Unaccompanied Children program. This program was created in 2005 to meet requirements under the TVPRA by offering legal orientations to children in the custody of the Office of Refugee Resettlement and legal counsel to over 26,000 children, both in and out of custody. The UCP was also terminated this year, and HHS continues to challenge a nationwide permanent injunction in appeals. Though funding has been restored temporarily, the future of this program and HHS's compliance with the court order remains in question. I cannot overstate the impact of these programmatic disruptions and terminations on the due process rights of our immigrant communities. In real terms, what these terminations mean is that people held in ICE custody and unrepresented people in immigration court have lost the opportunity to receive basic legal information, advice, and life-saving connections to pro bono attorneys. These disruptions mean that the attorneys have lost eyes and ears on the detention centers, effectively cutting off the necessary monitoring of human rights abuses. The defunding of legal orientation programs means that the sponsors of unaccompanied kids no longer receive resources about how to ensure that the child in their care can integrate safely in their community. It means that families separated under the first Trump administration's cruel zero tolerance policy have lost access to legal services as required under settlement. And finally, it means that ill adults no longer receive appointed counsel and now languish in detention unless they happen to be detained in the Ninth Circuit. In addition to the profound impact on our families, friends, and neighbors, these funding cuts have further exacerbated the limited capacity of the legal services field. By now, it should be clear to all of us, the administration's cruelty is the point. We are seeing that play out every day now in our news and in our communities. Ranking Member Jayapal, I'm here today because I believe the American public understands what this administration fails to. Due process means due process for everyone, and we are all safer when we can meaningfully assert our rights. When the administration tried to cut UCP, the American public rallied to send over 140,000 letters to Congress urging the restoration of legal services. Amid attacks on our immigrant neighbors that are an affront on our collective values, and alongside our inspiring network of legal service provider partners, we will continue to fight for these legal services programs to be restored so that no one is forced to face this country's immigration system alone. Thank you.
Thank you so much, Ms. Rodriguez, Ms. Rodriguez Schlegel. And now it's my honor to recognize Ms. Erfani for 5 minutes.
Thank you, Representative Jayapal, Ranking Member Jayapal, and members of this committee for holding this important hearing. My name is Azadeh Erfani, and I serve as Policy Director for the National Immigrant Justice Center. For the past 4 decades, NIJC has blended legal services and advocacy to protect access to justice for immigrants and asylum seekers. NIJC is in the Chicago Immigration Court every week, serving adults and children facing deportation proceedings. For many years, we were able to provide these services because Congress appropriated funds to ensure that those most vulnerable don't face a judge and ICE prosecutor alone. However, the Trump administration ended every single legal services program since taking office, leaving detained people, unaccompanied kids, people with mental health disabilities, and the families that Trump separated under the first term without an attorney, despite the incredibly high stakes of deportation. Their goal is very clear: creating a lawyer-free zone in immigration courts where due process is a distant memory. Choreographed alongside these unlawful funding cuts, ICE has also begun rounding up and arresting people at immigration courts. For weeks, NIJC has seen immigrants who are appearing to have their day in court be met with shackles, rushed into a service elevator, and disappeared into an abusive and deadly mass detention system. ICE is dismissing their court cases first, and then placing these individuals in fast-track proceedings known as expedited removal, where the vast majority will not have a chance to see a day in court. In addition to stripping lawyers away, ICE also wants to sideline immigration judges. And most recently, our attorneys have seen another alarming trend designed to end due process as we know it. Following the new ICE apprehension quotas pushed by Stephen Miller, ICE began arresting people who are complying with ICE's own reporting requirement while their cases are pending. NIJC's client, Gladys Chavez Pineda, is one among many who has fallen victim to this latest predatory practice. Ms. Chavez Pineda has been fighting her asylum claim after gangs threatened to torture her and her daughter, including by cutting off her daughter's fingers. Ms. Chavez Pineda has regularly attended her check-in appointments with ICE while fighting for her asylum case. 3 weeks ago, she received an unexpected message to check in with ICE the very next day. Ms. Chavez-Pineda complied, only to be shackled and separated from her minor daughter. She spent days sleeping on the floors of the Broadview Processing Center in Chicago, the same facility where members of Congress were unlawfully turned away last week while seeking to conduct oversight. And later, she was transferred to a county jail in Kentucky, even farther away from her daughter. Thanks to swift action from NIJC and our partners, the Seventh Circuit promptly blocked ICE from deporting Ms. Chavez-Pineda. Yet, ICE persists in jailing her. She's now fighting for habeas relief, like countless people who fear that they will be permanently separated from their families and precluded from pursuing their relief in violation of both domestic and international law. Ms. Chavez-Pineda's case shows a chilling overreach of executive authority. In addition to taking lawyers and judges away, ICE now seeks to also abduct people who voluntarily show up to comply with reporting requirements that they imposed. No one should be punished for doing the right thing, like appearing in court or for a check-in appointment. But as a result of these practices, ICE's detention system has reached the highest number of detained people ever recorded in US history, with 59,000 people behind bars under the guise of enforcing civil immigration laws. And who benefits from this shameful record? Private prison corporations. First, they made a fortune by operating the disastrous mass incarceration system that already has harmed generations of Black and brown people in this country, and now they are cashing in on the mass detention of people like Ms. Chavez-Pineda. We implore you and your colleagues to stand in solidarity, as many of you have, with our communities who are fighting to defend due process and the rule of law, both of which the Trump administration is sacrificing in the name of terror, cruelty, and corporate profit. Thank you.
Thank you so much, Ms. Erfani, and thank you to all the witnesses for your testimony. We will now proceed under the 5-minute rule with questions, and I will begin with my questions, but I wanted to acknowledge that we've been joined by a number of members, and we'll, after I finish my questioning, we'll go through in this order. Thank you for joining us, Congress members Delia Ramirez, Sylvia Garcia, Glenn Ivey, Chuy Garcia, Hank Johnson, Mark Takano, Zoe Lofgren, Rashida Tlaib, Jerry Nadler, and Judy Chu. Let me begin now with my 5 minutes of questions. This was incredibly powerful testimony today. I think you have really outlined clearly how unprecedented the actions of this administration are and how everything is interconnected in an attack on the legal system of immigration. At our first shadow hearing, we discussed how the Trump administration has been attempting to remove people to third countries, sending migrants to countries that they had never been to and had no connection to, with no notice and no due process. At the time that we held the hearing, that was blocked in the courts. But earlier this week, the Supreme Court shockingly allowed third country removals to resume. In a dissenting opinion, Justice Sotomayor, joined by Justices Kagan and Jackson, accused the federal government of, quote, flagrantly unlawful conduct, and called the majority's decision to intervene at this stage in the case inexcusable. The government, this is a quote, the government has made clear in word and deed that it feels itself unconstrained by law, free to deport anyone, anywhere without notice or an opportunity to be heard. Today, we are looking at yet another attempt by the Trump administration to eliminate due process by disappearing immigrants who show up to their immigration court hearings and deporting them without giving them their day in court. I want to start with Ms. Rowland-Kaine. These courthouse arrests by masked agents are terrifying, and there's a wide range of people in immigration court, including asylum seekers who have fled oppressive regimes, long-term undocumented community members, and others. Can you very briefly tell us what you've personally observed at immigration courts across the country and how it has affected your clients and their family members?
Thank you, Congresswoman. Absolutely. So we've seen over and over again dozens of enforcement officials waiting in hallways, waiting outside courtrooms, waiting inside courtrooms, ready to take people immediately when the motions to dismiss are happening, when they're granted, when they're not granted. This is happening across the country and across the courts in New York. As I mentioned in my earlier testimony, we've had 3 individuals that we worked with closely who were immediately swarmed as they exited the elevators by ICE agents, many of them in masks. And it's a untenable situation, and it's really creating a culture of fear to go to immigration court. You mentioned this in your earlier testimony, but it really has a chilling effect on respondents about whether they are showing up to court or not. And it's putting them in a position where they're given 2 terrible options, showing up to court and facing the possibility of being immediately detained, totally unknowing and unaware of the situation. And on the other hand, getting the in absentia removals that you had mentioned earlier. So we are absolutely seeing and have seen a phenomenal decrease in folks attending their court hearings because of this.
And this is a coordinated effort between immigration agents and the lead attorney for the government in these cases, both of whom work for ICE, correct?
It does appear that way. Government attorneys are Department of Homeland Security. We have witnessed government attorneys seeming to text message or message ICE agents who are waiting outside to alert them when they are moving forward with motions to dismiss, so that ICE agents are ready at the appropriate courtrooms. So it does appear coordinated for sure.
And after individuals are arrested outside of the immigration courts, where are they taken?
This is really a black box mystery, right? So in New York, at 26 Federal Plaza, folks are being detained on the 10th floor. We've had the New York delegation calling for oversight, attempting to access the 10th floor, being told that it's not actually a detention facility, and that folks are being held there temporarily. On the other hand, we're also seeing folks immediately removed to facilities as far away as Louisiana. And that's before others can intervene on their behalf. An important note that really doesn't get made enough is that once they're arrested, respondents don't have the ability to pursue the response to the motion, right? If it wasn't ruled on when they're in court. It's really difficult to make appeals because they're pro se, they're without representation, and they have to be informed ahead of time because this is not made clear to them to ask for those credible fear interviews to continue their asylum cases if they've started that process. They're just deported too quickly for that to go on.
Thank you. I just have a few seconds remaining, but Judge Tabaddor, you were an immigration judge for 15 years. Have you ever seen a scheme like the one that the Trump administration is implementing right now, where ICE counsel asks that cases be dismissed in immigration court so that immigrants can then be arrested by ICE agents?
I have never seen anything like this in my 15 years, and I had thousands and thousands of cases on my docket. We did see very, very rare, I think I could count on my one hand the number of cases where we were notified in advance based on very exigent circumstances, either severe histories of criminal convictions that came to light or something of really truly extraordinary circumstance. We were told that there may be an arrest, and it was more as a notice to us, and we could appreciate what's happening. But that is nothing compared to what I'm sort of seeing and becoming aware of through the news reports and what has been testified to today. So this is truly a systemic, as I mentioned, attempt to undermine the very framework of due process within the immigration court system.
Thank you so much, Judge. My time has expired. I now recognize Congresswoman Delia Ramirez for 5 minutes.
Thank you, Congresswoman Jayapal. First, I just want to thank you for convening today's critical shadow hearing on what is happening in the courts and what's happening in so many of our communities. As I heard testimony today, it was really difficult to keep my eyes from getting watery. Many immigrant families trying to do it the legal way expect a normal check-in when they attend their court dates. Instead, what we know and what we heard today with our witnesses is that Trump and Noam are weaponizing the courts to terrorize our communities. Their actions show just how little they respect the judicial branch due process and our constitutional rights. On May 21st, I was first alerted that there were ICE agents detaining people at the Chicago Immigration Court after having their cases dismissed. Given the administration's pattern of abusing its authority to wrongfully detain people and strip them of due process, I immediately sent a letter asking DHS to explain the presence of ICE at the court. I serve in Homeland Security. I sent their letter, and their answer was, well, you could imagine, silence, no response. Even worse, we heard reports that ICE agents in plain clothing were soliciting information from attorneys without disclosing and identifying themselves, a practice that must end and would be actually addressed by the No Secret Police Act, a bill that I'm proud to co-sponsor. On June 5th, I joined Benny Thompson, Goldman, and 81 of my colleagues to again demand answers on the weaponization of the courts. The DHS answer, silence, as always. Just send an email, as they say, and they don't respond. It is my understanding that the court to detention pipeline that this administration is creating renders any pending asylum claim void, stripping immigrants petitioning for asylum any legal pathway to enter the United States of their rights under US law. The weaponization of the courts violate people's right to due process. We know it disincentivizes people from complying with court orders. And frankly, it robs people from their opportunity to seek asylum. So it leads me to these questions to our witnesses, which I want to start by saying I'm so grateful for all of you being here and shedding light on what is actually happening every day. Ms. Erfani, first, thank you for your work and the organization, and then the work that the organization has done on both immigration policy and client representation in immigration court. For the record, and for everyone hearing today, can someone still seek asylum when they're in expedited removal?
So the process is incredibly harder, is the short answer. The process is supposed to be kickstarted again through what's called a credible fear interview, which Congress intended a long time ago to be a low threshold interview that people should be able to pass fairly easily if they have any kind of fear of return. But increasingly over the years, and starting with the past Trump administration, that interview has turned into a 4 or 5 hour ordeal where people are detained, unrepresented, often without proper interpretation, trying to present their claim alone. And so that means that they're really set up for failure. So dismissing these cases and then placing them in expedited removal effectively ensures that they're going to meet odds that they may not be able to beat at all, even though they had access to presenting their claim before in front of a judge.
And Ms. Erfani, this leads me to my follow-up question, but I think you answered a lot of it. My question was if you had faith that ICE agents were actually referring people to critical fear interviews, but it sounds like if in fact they do, when they do, they're making it nearly impossible for people who are going through the credible fear interview to be able to demonstrate to them that they in fact are afraid and fearful of their lives in returning back to their home country. So I want to follow up with another question here, Ms. Erfani. I want to make sure that we all understand this correctly. People are showing up to immigration court where they may be seeking asylum, and ICE arrests them after their case is getting dismissed. After that, what I'm hearing from you and from the other witnesses is that they're getting placed in expedited removal, where they again could be eligible to petition asylum. And as a result, if we follow due process, they could end up right back in immigration court. Is that correct?
That's correct. That speaks to the breathtaking inefficiency of all of this, in addition to the cruelty, for sure.
So then what is the point of all of this, Ms. Erfani?
I think the point is fairly clear, is to essentially push forward the deportation mill that this administration has been setting up from the start. ICE is the gatekeeper of who gets access to a credible fear interview. And many times we've seen that they have actually not provided that opportunity to people. So in many ways, this is, they're setting up people to fail, and they're, taking away the judges in the process too.
Yeah. So I would agree with you and say to you that I think that this is a sick catch-22 that this administration is creating with their weaponization of the courts. Either our neighbors show up to their hearing and risk being placed in detention, or they skip their hearings and are ordered to removed in absentia. It's an impossible, cruel choice. It's tactics like this that have informed my calls in the Committee of Homeland that Kristi Noem needs to resign. And I'm so grateful that Congresswoman Jayapal is convening today's hearing to help the American people understand exactly what is happening every single day around the country. Congress needs to continue to demand accountability for their illegal, unconstitutional tax and due process and the legal immigration system that we should be creating and upholding. I want to thank Congressman Jayapal, and with that, I'd like to yield back.
Thank you, Congresswoman Ramirez. Next, I'd like to recognize Congresswoman Zoe Lofgren for 5 minutes.
For some reason, my video will not start. This hearing has been very helpful. Honestly, what's happening as you've described it, is not at all what Congress had in mind when we passed these laws. The intention was for someone to have an opportunity to have their case heard for asylum. And honestly, it's a failure of imagination. I don't think any of us ever imagined that the government would dismiss the cases to prevent the orderly administration of the law. And so my question is really what proactively might be done to stop this outrageous due process violation by the Trump administration. One thought I had, and I don't want to get into the legal strategy, but I'm wondering whether we might seek injunctive relief against ICE from scheming in this way, whether we should get a prohibition on dismissing cases unless the asylee applicant agrees. This is really a miscarriage of justice. And I just wanted to throw that out because obviously our colleagues on the other side of the aisle have not shown much interest in defending the laws that they all voted for years ago. And we're in the minority. They have the votes by 3 to outvote us. So we've got to turn to the third branch of government to make sure that the constitutional right to due process is protected. Any thoughts on proactively going after this from any of the witnesses? And all of you have been fabulous, by the way. Thank you.
I mean, I'll jump in, not so much because I have the magic answer, but just to share with you that I understand that the government has now filed a lawsuit against every single judge in the District of Maryland based on a standing order that was issued by the court after there were very repeated examples of the government disregarding court orders in habeas context and sort of disappearing people before they've had their chance to even sort of request due process. So I think at this point, it does seem to be that the courts are the remaining standing branch of the government where there may be an opportunity to hold the executive branch's lawlessness in check, but we are in dark times.
We are in dark times, and I saw that as well. An extraordinary abuse to file so as to prevent or try to prevent the judges from even hearing matters and to force recusal, which I would hope they would not fall into, since this is obviously a ruse. I know that other members have questions, so I'm not going to go on further other than to say thank you very much. And we are going to be your partners on this committee in trying to defend due process in the face of really a lawless administration. And thank you, chairwoman to be Jayapal for organizing this hearing.
Thank you so much, Representative Lofgren, for all your leadership on this issue and for your questions. Now, let me recognize Congresswoman Sylvia Garcia from Texas for 5 minutes.
Open the video.
Can y'all hear and see me? Great.
Yes.
Well, first of all, thank you to all the witnesses and thank you so much for being in the fight and being there to zealously represent your clients as we're all charged to do as officers of the court. First, let me say that as a former judge and someone who has been working on this issue for so many years, I find it just outrageous that they are going and attacking the courts and weaponizing them the way that they are and preying on people, because that's what they're doing. They're preying on people, waiting for them to come outside and do this arrest. I have been visiting a detention center every time I go home for a work week for some time now. But because we started getting so many calls about one of our courthouses, I went to one last week. I did not see anyone get arrested, but I certainly did see what I would consider collusion, if you will, by the so-called, I think, Ms. Rowland-Kaine, you called them government lawyers working for DHS, but they just seem to be in collusion with ICE, and there seemed to be a very friendly relationship between the government lawyer and the judge on the bench. And I didn't know whether that was just common or not, because frankly, my focus has always been on detention centers, particularly those of unaccompanied minors, because I think they're the most vulnerable. And I have been to detention centers in Texas, New Mexico, California, Florida, Georgia, New York. I've seen the for-profit, the nonprofit, ICE run, faith-based run. So it just struck me as the first time that I have seen, someone who was supposed to be the independent third party, the judge, just almost take signals from the lawyer that was at the table. And obviously, too, what really struck me and just one of the cases almost brought me to tears, because the people there clearly did not understand what was going on. The judge continued to talk in legalese and citing regulations, etc. And the interpreter just interprets exactly what the judge says, and that's their role. But there was no one there to really explain to the family that was there just what really was happening and what the consequences would be of their answers. So my question to you all is, I'm convening a group, and I've already talked to several of our stakeholders in Houston to just try to get more pro bono lawyers, paralegals, whoever we can find that can help represent some of our constituents, especially the children, unaccompanied minors. So is this like par for the course all over the country that people are appearing without lawyers and they're just, frankly, just getting ramrodded? It's like they're not getting what we used to call in judging 101, their day in court. They're not getting their opportunity to be heard. So, Judge, I'll start with you. Is this the way it's happening everywhere, or is this just happening in Houston?
Well, what I can share is a few sort of general remarks about just the setup of the immigration court. You mentioned a little bit about the relationship of the immigration judges with the department's trial attorneys, and I think most people don't recognize that the immigration court is within the Department of Justice, and that the Department of Justice is in regular communication with the Department of Homeland Security. And so even sort of coordinations and any sort of there's very regular communication between the two departments, and there's coordination at the top, which then sort of trickles down. So I think that's been one of the biggest problems, is that the immigration judges who are doing their best to be that independent decision maker are put in a system where they are essentially being sort of maneuvered, and the messaging that's being given to them is very strong right now, that we want deportations, we want we want high numbers, and also, as I mentioned, they are now being told that you're no longer protected under the civil service. You are no longer part of a union. You are an at-will employee. So I think you're seeing people who are really trying their best, but because they themselves are put in a position of between a rock and a hard place, it is very difficult to try to be that sort of independent decision maker in these cases. I think they're trying, but it is very difficult. I remember myself during that first Trump administration where the union was decertified and quotas and deadlines were introduced. And those were sort of some of the very first systemic effort to undermine the independence of the judges and try to keep the veneer of a judge, but at the end of the day, have a system that really has its fingers on the scale. So I'm not sure if
there's a quota system on the judges too, because we know there's a quota. I'm sorry, there's a quota for the 3,000 deportations, and I think a lot of this stuff is being done to meet those quotas. So you're telling me that even the judges have quotas?
During the first Trump administration, yes, that was the number one thing, was quotas and deadlines on judges. And during the previous administration, it was lifted. And then this time around, the protections of the job has now been lifted. So the judges have been told you're at-will employees, and dozens of judges have been fired.
Sorry, Madam Chair, I'm just trying to clarify if in fact there is quotas for the judges, because that would be alarming to me.
My understanding is that the dashboards remain, and that the judges have been told that their numbers are being observed, but that there isn't any specific quotas at this point.
Thank you so much. I do need to move on to the next member. Thank you so much, Congresswoman Garcia. And next, let me recognize Congressman Chuy Garcia from Illinois.
Thank you, Ranking Member Jayapal, for having this shadow hearing on this administration's many unconscionable abuses of immigrants. As my colleagues have described, ICE has targeted courthouses to advance their cruel and racist anti-immigrant agenda. They're asking judges to dismiss cases and then immediately detaining people who are following the law and has shown up for their hearing. And it gets worse. They're also luring immigrants to check-in appointments and then detaining and deporting them with no notice to the immigrants or their families. And again, after they followed the law and did what they were supposed to do. And because Republicans know what they're doing is illegal and unpopular, they're doing everything they can to hide it, including by preventing members of Congress from exercising their legal oversight authority to visit detention centers. All these tactics have been used in Chicago. ICE agents showed up to our immigration court and detained at least 4 people who had shown up for their hearings. They also detained people at the check-ins, including a mother with no criminal record who had applied for asylum and complied with all requirements. The case was referenced earlier. When my colleagues in the Illinois delegation and I last week heard from community members and partners that she and others, including at least another of my constituents, were being detained at the Broadview Processing Center without access to basic necessities like food and bedding, we exercised our authority enshrined in the federal statute. That is to visit the facility to see what was happening, but they refused to let us in. And finally, a masked man who refused to identify himself told us to make an appointment via email. So I've seen firsthand what's happening in our immigrant communities like the one I represent, and how blatantly this administration is violating the law to cover up their abuses. Ms. Erfani, thank you for joining this shadow hearing, and thank you for your partnership with my office on these and many other issues affecting our community. You spoke to this in your opening remarks, but could you elaborate on what else we're seeing in Chicago, specifically on the importance of congressional oversight in this moment of mass detentions?
Thank you, Congressman, and we're really grateful that you attempted to exercise oversight even though you were unlawfully precluded this past week. What we're seeing in Chicago is really playing out across the country as well. We're seeing the increase of plainclothes officers that are in the immigration courts attempting to essentially whisk away and handcuff people who are showing up for their hearings. We've seen that for weeks. And we've seen that repeat itself as well within the context of the ICE check-ins, as mentioned. We're also seeing Chicago being ground zero since the beginning of the administration for some of the retaliatory attacks from this administration, simply because we have laws that actually protect everybody, including laws that are essential to domestic violence survivors, access to help, and ensuring that, the city is welcoming to everybody. So a lot of the actions that we're seeing have been both punitive towards immigrants and cities who are trying to do the right thing by their residents. And, disappearing all of these residents to really far away states where it's harder for them to access counsel, and it's incredibly harder on families, including people who have been detained for 5 months and counting.
Thank you for that, Ms. Erfani. Again, my entire team and I are grateful to you, NIJC, and the entire immigrants' rights advocacy community. This is a moment of crisis in our country, and that's why we need to double down on oversight on our legislative proposals to fix our immigration system, and of course, our commitment to dignify and the humanity of all immigrants and all people. Thank you, Ranking Member. I yield back.
Thank you so much, Congressman Garcia. Next, let me recognize for 5 minutes, Congressman Glenn Ivey from Maryland.
Okay, there we go. Sorry about the delay there. Wanted to thank you, Representative Jayapal, for pulling this together. As usual, your leadership on this front and many others has been outstanding, and we thank you for all that you've done. Thank you to the panelists for your great testimony and insight. Thank you to my colleagues for their comments too. I've got to dash off to an appropriations hearing shortly, but I did want to mention a couple of things quickly that are kind of tangential but relevant to this discussion. In appropriations a few days ago, we actually had a debate about including report language that would direct Homeland not to make these detentions at courthouses. And that was Representative Escobar that offered that. It was second degreed by Cisco Mani from Arizona, but didn't eliminate the language entirely. He's getting heat from his constituents back in his home district. Cisco Mani's a Republican, for those of you that don't know, but he's in a marginal district where he's in close races. So I think if we keep the pressure on, I love the work that you all are doing in court. It's critical. And the judiciary has been our first line of defense for sure over the first 6 months or so of the Trump administration. But, people are starting to hear the challenges that this is creating. And for people with large Latino populations and immigrant populations, I think they're starting to get some pushback about it because people are, as Representative Jayapal pointed out, there's a real catch-22 here about whether people should go to court or not. Many of them have been following court orders for years, and now they've been put in this Hobson's choice of whether you go to court and risk being detained and whisked away and deported. But if you don't go, then you are violating your status and become vulnerable for deportation on those grounds. One other quick point I wanted to mention here too was when I was defending Representative Escobar's amendment and in the form of report language, the point I made was that when I was a local prosecutor in Maryland, and we had a lot of MS-13 cases in our jurisdiction, one of the things that we spent a lot of time doing was making sure people understood that as witnesses or victims, they needed to come to court and not be afraid to be deported or have the legal system come down on them, because the criminals were telling them, you better not go to court or you're going to get deported and separated from your children. That was especially acute in domestic violence cases. Men would be abusing their spouses or significant others, but they'd say, if you report it to the police, you're going to get deported and you'll be separated from the kids, and they'll be left here with me. So one of the things they needed to consider was the impact of what this is doing to people from the standpoint of not just concern about deportation from the immigration aspect, but it's actually discouraging people from coming forward and helping the local and state governments prosecute the actual criminals that we're worried about. Trump ran saying he was going to get the murderers and rapists and gang members and all that stuff. He was going to focus on them. I think everybody'd be fine with that, but he's starting to focus on people who are just doing everything the right way, making a living, going to work every day, paying taxes, sending their kids to school. Same issue with going to church about making arrests or detentions there. Say we don't want to discourage that either. So I've got to dash off. I'm sorry, I don't have time for a question, but I know we've got a lot of other members who are in line there too. But thank you to all of you for what you're doing. Let's keep the fight going. Let's see if we can push it here in Congress too. In the House, there might be a crack that we can squeeze through on this issue. I think they're starting to feel the heat, and we may be able to make a difference in pushing forward on this. Thank you, Jamila, for all that you're doing.
Beautifully said. Thank you so much, Representative Ivey, and for all of your work on this and your leadership on this issue as well. Let me now recognize for 5 minutes Representative Hank Johnson from Georgia.
Thank you, Madam Chair, for holding this hearing. And I want to thank the witnesses for your testimony today. And I also want to thank you for the ongoing work that you're doing in this world of terror and intimidation and fear. I know it's not easy for you all to go to work every day under those kinds of conditions. President Trump claimed that he would go after the worst of the worst, but instead his administration is zip tying little children as young as 9 years old when they show up at immigration court. What danger does a 9-year-old child pose that would warrant that? Even worse, the Trump administration is specifically targeting immigrants who do everything right and who show up at their immigration hearings. These people have claims of asylum or other legal protection, and they deserve their day in court. But the Trump administration is bypassing due process protections by requesting that these cases be immediately dismissed and then sweeping up immigrants in a dragnet as they leave the courtroom. By placing these immigrants into expedited removal, the administration is ensuring that there is no time for them to access attorneys. And that is exactly the point. People say that they want immigrants to come, quote, the right way, end quote, but Donald Trump is destroying faith in the legal immigration system. The message is clear. If you show up to your immigration hearing, you will be dragged away on the spot, never to see your family again. If you bring your children, they may end up in zip ties. How can anyone trust the immigration courts and American laws anymore? Ms. Schlegel, your organization had a contract with the federal government to help children in immigration court. Is that correct?
That's correct, Representative Johnson. We currently have a contract with the Department of Health and Human Services, Office of Refugee Resettlement, to administer the Unaccompanied Children Program. And that program is designed to offer legal orientations and screenings to children in ORR custody, as well as representation to children in and released from custody.
Has that program been defunded or terminated or in any way mitigated in terms of your ability to render services?
That's correct. The program was abruptly terminated in March 2025, and it is the subject of litigation in the federal courts. The case name is Community Legal Services of East Palo Alto versus HHS. We are not a party to the lawsuit, But we do know that in the Northern District of California, the judge issued a nationwide preliminary injunction requiring ORR to reinstate the program. A month later, our contract was reinstated, but its future remains uncertain, particularly as the administration continues to push the case in appeals to the Ninth Circuit.
So are you currently rendering services to children under that contract?
We are.
And how many children are you representing at this particular time?
There are approximately 26,000 children with open immigration cases being represented by UCP providers, and that includes children in all 50 states and the District of Columbia.
So now children, sometimes they're toddlers. Are there instances where they show up to court unrepresented? And if so, as they sit, I guess, in a big chair, too big for them, and they sit there listening to a government lawyer, an experienced government lawyer, rambling on about arcane regulations. Is that the way it works in that kind of a situation?
Improbable it sounds, that is correct. Unfortunately, due to the limitations of the program's funding, we are not able to represent every unaccompanied child. And that does mean that some children do go to court without an attorney, as young as toddlers.
And are those children getting their cases dismissed as well?
We have not heard about that to date, but that's not to say that there may not be situations where that is occurring.
Just Tabaddor, anything you'd like to add before I run out of time?
Thank you, Congressman. No, I don't have anything in addition to add. Thank you.
Thank you. I yield back.
Thank you so much, Representative Johnson. Very important set of questions. Now it's my honor to recognize for 5 minutes Representative Mark Takano from California.
I thank you, Congressman Jayapal, for convening this hearing. I'd been hearing about from some immigration attorneys in my I've been hearing from immigration attorneys in my community about this practice of the collusion between the immigration judges and the immigration counsel, the prosecutors, dismissing cases in a collusionary way, and then ICE agents arresting asylum seekers. She told me that she believed that this was going to contribute to tremendous social unrest. And this was prior to the Los Angeles uprisings over immigration. And so she was prescient in that sense of what she believed would arise from all of this. Judge Tabaddor, is it accurate that that there is a collusionary something that there's collusion between the immigration judges and what do we call them, immigration prosecutors or immigration attorneys for the government?
Thank you, Congressman, for the question. I'm not aware of per se, quote unquote, collusion, but I think they don't need to get to collusion because they've set up the system in a way that is going to have their fingers on the scale to get the results they want. What I mean by that is, again, the immigration court is within the Justice Department, and DHS and the Justice Department are in regular communication. DOJ, through its leadership, has informed the judges that they believe even in cases where the government is seeking dismissals, the judges don't even need to give any sort of opportunity for the individual to respond. So I think what has happened is that the judges are, again, placed in between a rock and a hard place. It's very clear where the government, where the president wants to land with these types of cases. They're told that they are going to be asked to dismiss these cases, and they're told that they can go ahead and do it without any sort of notice. So I don't think you need to have, quote unquote, collusion. I think the messaging, the infrastructure, the system is going to get you the result that you want when you set it up that way. And so instead of focusing on, oh, collusion between an immigration judge or the trial attorney. I think we really need to be thinking about the system as a whole, and why is it that we're allowing a court system to be within a law enforcement agency, so that in that context, the individuals who are being tasked with being judges are put in that rock and hard place situation.
So Judge, just help us recall what the system is supposed to do. The idea is that we have people from around the world who are escaping political persecution. There's a very specific criteria under which you can come to this country and claim asylum. And we can't get to everybody's cases right away, so people are here legally, right? Asylum seekers are here legally, and they have to report to court or check in every so often. And so long as they do that, they're here illegally. Is that right?
That's correct. So under the law, you have a right to seek asylum and present your case, even if you appear at the border without documents, or even if you're in the United States without authorization. Under the law, you have that right. And the government makes that initial decision when they encounter you on whether they're going to allow you to pursue your application directly with USCIS or through the court system. And while you're going through that process, you have permission to remain in the United States, and you should be allowed then to show up for your court cases.
So why do we have why does it take so long for some of these cases to be adjudicated? Is it just we don't have enough judges to do that?
I think the lack of judges and resources is certainly part of it, absolutely. But I think what has also happened throughout the years is that the courts have become essentially a pawn for the administrations that come in. There's been a lot of docket shuffling that's happened with every sort of change of administration. There's been a constant docket shuffling, and that really contributes to the delay in the cases to be able to go through that process. So it is certainly part of it is the lack of resources, but it is ultimately really a systemic issue as well.
Thank you. I yield back. Thank you so much, Chair Jayapal, for this. This is wonderful. I've gained some understanding about this incredibly bad faith enforcement of our laws. It's heartbreaking.
It really is. Thank you so much, Congressman Takano. Now let me recognize for 5 minutes, Congresswoman Rashida Tlaib from Michigan.
Thank you so much to our amazing advocate on immigrant rights. Before I got here, Pramila Jayapal was always on the front lines when it comes to immigrant rights and civil rights. So I really appreciate all of you. One of the things that I know many of my colleagues already asked in regards to the courts, but I want to ask you all before they get to the courts, what we're seeing in the northern border in the 12th Congressional District, and many of the families we work with Michigan Immigrant Rights Center, Michigan United, a number of advocacy organizations, and this is for all of you, is what we're noticing is, change in policies. And I think it's because of this mandated kind of push of a quota of the number of folks, treating them as if they're animals and not actual people, and following the due process and the rights of those immigrant neighbors, is that before they even get to you, Judge, or anyone else, before they get to that process, there's an in-between where they're with our, what I call Field Operation Border Patrol, and they're in facilities like in our northern border. We've had a case where a mother with U.S. citizen children was at the office space for, I believe 12 days or so. We've had other claims of 5 days. This whole thing around being disappeared before they even get access to judicial process or their due process is many of our immigrant rights organization and myself as a member of Congress cannot find my immigrant neighbors before they get to the ICE system. And this is something very concerning. And I want many of my colleagues to know this, where we want to make sure they have access to legal representation, or just making sure their family knows where they are. When we say kidnapped and disappear, we really mean it, because when they get stuck in that system, before they even, because maybe it's this whole idea that they don't have space at a facility or whatever, but before ICE touches them, we can't find them in the system. And I think that is very dangerous in regards to us being able to advocate and also making sure that U.S. citizens and those that have legal path are not being, again, ripped away from their families because folks, are just kind of don't care because they're brown immigrant folks, don't care that they have a legal path and access, again, the civil rights or the constitutional rights. So I want to ask you all about this. And if you were immigrant rights organization, if you are experiencing that with your cases, because before they get to the courts, and we've had these incidents in the courts where, yes, immigration is there, and we are trying to track a lot of that right now. But the biggest issue and concern that many of us have is that we can't find our clients, we can't find our family members and so forth before they even get to ICE and before they get to the court process. Can you all talk a little bit about that? Because I want my colleagues to know, I put in a research request, I want to understand this, but when I call the people that detain and we know they're there, they say, well, we don't have access to that system, that's ICE. And you all have seen this before. Oh, it's not us, it's ICE, or it's not us, it's Border Patrol. And we're all being pushed in all these different directions. But one thing that I'm really concerned about is the fact that we don't have a documentation of having somebody in our custody and being able to have access to that information. Anybody comment about?
Thank you, Representative Tlaib. I will just jump in to say I think the level of of inscrutable system that we're seeing at this stage is unparalleled compared to what we've seen before. It's really hard to know where people are. The ICE detainee locator is often not updated, and it's just hard for experienced attorneys to find their client, let alone family members who may not know how to navigate the system. And there is no parallel system at the moment in terms of CBP. So when someone is actually taken into custody, as you highlighted, by Border Patrol, then it's even more of a black box to actually track them down. We have to ask ourselves, is this a system that makes any sense for a democracy, for a country that should be abiding by the rule of law and affording everybody due process?
If I could just add, Representative Tlaib, we've seen this before from the Trump administration during the first term when families were separated at the southern border. It was oftentimes impossible to figure out where the children were sent, where the parents were, and reunifications are still happening today. So it is the damage is just rippling over years, and we suspect that will continue from now on.
And I know my time is up, but Rep. Jayapal, we even as we come together, we know we're going to have to address the aftermath of this egregious cruelty of the system. And I think requiring, again, better being able to track again, as soon as they touch any of immigration agencies, it should be documented who has them in custody, how long, if there's U.S. citizen children, so forth, because she's absolutely right. We still are seeing, even in Michigan, we got dozens of children that we could not find their parents afterwards because they didn't care. They just treated them like they're animals. Pramila, they just grabbed them and separated them and sent them back without their kids. So again, thank you so much for this hearing. It was very.
Yeah, thank you so much for being here. And I think for your very important suggestions for how we bring some accountability around where people are within the system. Now let me recognize for 5 minutes Congressman Jerry Nadler, who has been on the front lines. His office has been on the front lines of a number of these situations. Congressman Nadler.
Can you hear me now?
Yes, go ahead.
Oh, okay. First of all, thank you, Pramila, for holding this hearing. I have a couple of, my first question is, if someone has applied for asylum and is scheduled for an asylum hearing, and the judge at the asylum hearing dismisses the case, can that person be immediately seized by ICE as he walks out the door? Somebody?
I believe that's what, good morning, Congressman. I'll jump in, but I want to also make sure our panelists are not too shy about jumping in, since it's technically not just the immigration judge, but as has been explained, that's what's happening, is that when the courts are dismissing
Yeah,
those cases.
But that's what's happening with someone who has an asylum claim also.
Yeah, so if the case is being dismissed, traditionally, the individual was allowed to then pursue their application before USCIS. But now the DHS is taking enforcement action and putting them in these expedited removal processes.
All right. Secondly, I observed, Congressman Dan Goldman and I observed immigration court. We observed two cases in which the government moved to dismiss. The judge asked if that was okay. The defendant said, no, I do not want it. I do not want the case dismissed, and a hearing date was set. But that can only happen, obviously, if that person had legal advice who told him to decline having his case dismissed, because having your case dismissed sounds good. Thirdly, we were told that people were held for several days, including sleeping on benches, in a hearing room upstairs. We demanded the right to see it because this law says we're allowed to see detention facilities. We were told it's not a detention facility, even though people are being detained there for several days, admittedly. It's an office, and they categorically refused to let us go there. Is there anything that you think could be done about this kind of situation?
I think, Congressman, to your second question and second point there, when folks are being asked by the judge if they would like their motion to be dismissed, and they're saying no, it is disingenuous in a lot of ways that when folks are continuing their case, there's that idea that they can then pursue their asylum applications outside of the courtroom facility. Folks are not being, if they're not informed by advocates or lawyers in the courtroom, they are not informed about their right to seek credible fear interviews when they are in custody. And they're not being informed of that by immigration judges when the judges are moving forward with their dismissals. I think that sort of leads to the importance of ultimately representation, because it is the folks who are unrepresented, who are appearing pro se, who are being targeted at this point, right? So Representative Jayapal is a strong advocate for the Fairness to Freedom Act, and this would create a universal right to counsel for immigrants in immigration court. And that is why it's so important that we set up these tools for our immigration and our immigrant communities to succeed in immigration court. Because without that representation, without projects like Front of the Court there to really inform pro se respondents who are appearing in this process alone and uninformed about what it looks like, they will not get their fair day in court.
All right. Next, there's an immigration court in the same building as my office. People were watching outside as ICE people grabbed people walking out of the courtroom. It was getting somewhat heated, so my staff invited some of the clergymen, some of the observers down to my office. They came down, they were sitting there, and suddenly ICE burst into the office. My staff demanded a warrant. They said, we don't need a warrant, and proceeded to arrest one of my staff people on the grounds that she had assaulted him, which was ridiculous. And the video shows he had assaulted her. I managed to talk them out of it later. But a young woman is traumatized. She was placed in shackles and then in jail downstairs. Has this happened elsewhere in other congressional offices, as far as you know? As far as anybody knows?
I believe we're aware of similar situations, but certainly there is a risk given the heightened levels of violence surrounding the enforcement actions.
Thank you, Congressman Nadler. We've been trying to keep track of, what's happening. We often get contacted on the Immigration Subcommittee for any of these incidents. That one at your office was truly horrifying. And so we will continue to keep track and do everything we can to hold folks accountable. Thank you for your leadership. And last but certainly not least, I'd like to recognize the Chair Emerita of the Congressional Asian Pacific American Caucus, such a strong advocate on immigration, Representative Judy Chu, for 5 minutes.
Hello. Well, due process is under attack in Trump's America. Immigrants are being abducted from immigration courts when they follow the rules by showing up for their day in court. And in LA, this is evident so dramatically. Donald Trump's ICE forces came storming through downtown LA, sweeping up not just immigrants, but even US citizens and hauling them away to detention centers. I got contacted by advocates who were sick with worry since they could not even locate where they were, could not make contact, and had no way of knowing whether the detainees had food or medicine. So the next morning, 2 Congress members and I drove to the Adelanto detention facility to exercise our lawful constitutional responsibility of oversight. But when we showed up, ICE actually closed the chain link fences right in front of our eyes and locked the gates with chains. They refused to let us in, defying the law that states that Congress has the right to conduct oversight. But we decided to return and just again try to get in. And finally, we were able to do that. And we did see horrific conditions for detainees who had no basic necessities and were unable to even call lawyers or their families. And then two days later, I rushed to the Metropolitan Detention Center because of suites that were in my city of Pasadena, where six immigrants were just taken off the streets with the ICE agents who did not identify themselves. But once again, they didn't let me in. So it's incredibly alarming that not only is the Trump administration eroding due process at immigration courts themselves, but he's shipping people off to detention centers where members can't do their legally authorized oversight. And then what they're doing is just sending these detainees to other states and even to other countries' prisons. So, Mr. Erfani, how does this lack of due process affect us, and what alternatives do we have for us conducting our legally sanctioned oversight?
Congresswoman Chu, first I applaud you for the oversight that you have attempted and successfully conducted in these instances in response to the horrific actions that we saw in Los Angeles. I will say that, what we're seeing play out in the courts is certainly a due process crisis, which means that it's also a constitutional crisis. But I would say that what's happening in terms of turning away Congress members such as yourself is another aspect of that crisis, because essentially it is one branch of government telling the other that they are not allowed to exercise their duty under the Constitution. And, no such executive overreach should be permissible. And I think it remains incredibly important for members like yourself to continue to push to actually shine a spotlight on the conditions that our immigrant communities are suffering throughout this country and across the world now because of this administration, again, because of the historic rates of detention that we're seeing.
Thank you for that. And do you think there's a legal basis to challenge these blocks on our oversight?
I would certainly encourage your office and members to investigate a potential legal basis, Congresswoman. I think this is absolutely egregious in terms of what is happening.
Thank you so much, and I yield back.
Thank you so much, Congresswoman Chu. This concludes today's forum. I want to thank again our panel of witnesses for participating and the members that came, who are seeing what's happening and the consequences of these attacks on the immigration legal system around the country. This has really been an extraordinary hearing, and I think we will make sure that we continue to do everything we can to protect our immigration system and the fundamental constitutional rights that are afforded to everyone. And as you have pointed out, the oversight that Congress has in ensuring that we do continue to be a check and balance on unconstitutional actions of any administration. Thank you all so much for being here. This concludes the hearing. And I know that there are a couple of reporters that are on. And if there are any questions from reporters now, after this hearing is now concluded officially, happy to take those. You can just use the raise hand function, and Jenna Berenger will help me call on you. And if there are none, then thank you again all so much for being with us and for all the work that you're doing across the country.
Thank you for having us.
Thank you very much.
Thank you.